protection.
Jonathan, we do find, I don't know what the ruling is yet, but we do have Purdue Pharma. And if you're familiar with that case, this is about the opioid crisis bankruptcy, where the Supreme Court was looking at the settlement and deciding whether it should stay. Is that correct?
Yes, and that is we have been waiting for that case as well. I haven't gotten the case pulled up.
So there were thousands of lawsuits that were taken against the drug maker stemming from that opioid crisis. And then there were bankruptcy proceedings. They were paused until an opinion is issued. And the settlement has been criticized because it would basically shield the Sackler family and owners of the company from personal liability over their role in the opioid epidemic. So, we just had a report from Brian Yennis that the families of people who have had their loved ones fall to an opioid epidemic or even to fentanyl, which is the new iteration of it, they are paying attention to this. They're very upset about it. We don't know what do we know what the ruling is?
So the U.S. Supreme Court, Jonathan, they blocked Purdue Pharma, the bankruptcy settlement that would shield the Sackler family owners from any lawsuits tied to the opioids.
That's interesting.
That's the ruling. Is Shannon with us?
Yep.
Shannon, you want to weigh in here?
Yeah, so you guys have laid it out perfectly. There was a big settlement that came together that would take billions of dollars from the Sackler family and put it into trust accounts that essentially would be paid out to answer claims against harms. But this deal came together with not everybody who's a potential third-party claimant to this meeting, somebody who would have a claim, signing off on it. So the question was, did the bankruptcy code or court allow this to happen? In a very split decision here, it looks like the court is saying no. It says Congress may choose to add to the bankruptcy court special rules for opioid-related bankruptcies as it has for asbestos-related cases, or it may choose not to. Either way, if a policy decision like that is to be made, it is for Congress to make. They go into, what's happening with the dissent. It's fiery. It's back and forth. There are numerous dissents. But it looks like this is a 5-4 split at first look. And again, it looks like that bankruptcy deal that came together in the billions, which would have shielded the Sacklers from a lot of other civil liability. The court is saying can't do it under the laws that exist. And as they often say, if this is going to change, it's up to Congress to change the law. At first reading, that's what it looks like they're saying. So they're sending it from that side of Capitol Hill back to this side of Capitol Hill.
Yeah, Shannon, just to follow up, it's a 5-4 Gorsuch opinion. Kavanaugh, Roberts, Sotomayor, and Kagan dissented.
Yeah, and it's an interesting put together.
Sorry about that, Shannon. Jonathan, you want to jump in here?
Yeah, this has been a case that many of us have been waiting for, particularly those of us who teach torts and other areas that can touch on the opioid crisis. And this was a massive settlement, but what the company and the family, the Sackler family, got out of it was effective immunity. And after the deal was inked, and many of the litigants were delighted because it was a big figure. It was a windfall in many respects, but it also gave this family a sweeping protection. And later, states began to object and say, well, we're not done yet. We don't believe that you should be entirely protected. And litigants started to come forward and say, how about us? We want to see more action here. This is going to create further uncertainty as how this plays out in the future, because the effort here of the court was to try to create a sort of resolution for all the parties involved, including this industry. That resolution has now proven evasive.
Shannon Bream, you're continuing to read through that opinion. So a lot of these opinions do come out 9-0, 8-1, but the more difficult cases tend to come down to these split decisions, like this one.
Yeah, and exactly. And think about the fact that we had a 9-0 on something like the states that try to keep President Trump off the ballots, the ballot access issue. You also had a 9-0 decision leaving mifepristone, the abortion drug, on the market. So the court does speak with unanimity quite a bit. But the tough ones, you're right, come down to the final days of the court. In his dissent on this, Justice Kavanaugh really laments for pages about how the court is getting this wrong. He says opioid victims and other future victims of mass torts will suffer greatly in the wake of today's unfortunate unfortunate, and he calls it destabilizing decision. Only Congress can fix the chaos that will now ensue. The court's decision will lead to too much harm for too many people for Congress to sit idly by without at least carefully studying the issue. So both sides sound like they think Congress has got to fix this problem. That's the one thing they agree on, but they don't agree on the application in this particular case.
Jonathan, we continue to read through here. Obviously, we're at 10:11. This means we could still, it's open to get some more rulings down here, but we're starting to near the point where maybe this is it for the day.
We got a couple more.
Okay. Here we go.
Jonathan, as we look for that, just to confirm, so with this decision, does that mean that any of the families who are expecting to get some of the settlement money, is that on hold now, or will that go forward?
Yeah, I have to drill down further on the decision because I don't want to say with great confidence it's a fractured decision, but I do think that is in doubt, that this really throws it back into a great deal of uncertainty, which is what the dissent is saying. I think that this court is consistent in an important respect. The majority of this court has really been hammering away in recent years to reinforce the authority of Congress, that these matters need to be resolved by Congress. They need to be resolved with clarity. We may be seeing that in a couple of the remaining cases where the court is saying, we're not going to become a super legislature, and Congress needs to step forward, speak for the nation, resolve these questions in the political process. And so to some degree, it reinforces that. But for these families, they're going to say, we're being once again left in this ambiguous zone as to when we can have recovery.
That's exactly right.
Looks like the SEC versus Jarkessi case came in. Not exactly one of the top ones we were looking for, but they're still coming in, Shannon.
Yes, and this case was dealing with essentially if the SEC brings action against somebody, do they have a right to go beyond the administrative law judge? Do they have a right to a jury under the 7th Amendment? It looks like the majority here is saying that they do have a right to pursue this as a jury trial. It appears to be a 6-3. Along the splits that many people often think this court is going to go. I'm looking through, Justice Gorsuch has written a concurrence as well. But it looks like what the majority is saying is that, yes, I mean, if you get caught up in one of these actions as a defendant or potential defendant here, you do have the opportunity to go beyond just these administrative tribunals, and because of the 7th Amendment, have a right to a jury trial. We'll keep
that has been a really big issue. In fact, the Wall Street Journal editorial board has editorialized on this several times. It's interesting that Sotomayor dissented, and she is joined by Kagan and Jackson. So those are the three that were appointed under liberal left-wing presidents.
To read you, and we do know that there are more decisions, at least one more, maybe more than that coming. The conclusion of this case says a defendant facing a fraud suit has the right to be tried by a jury of his peers before a neutral adjudicator. Rather than recognize this right, the dissent would permit Congress to concentrate the rules of prosecutor, judge, and jury in the hands of the executive branch. So if it stayed within that administrative law judge, they're saying it would be too much power concentrated one place. 7th Amendment, in this case, does say a jury trial is permitted.
Jonathan, let me put a question to you as we wait more to come in here that I asked Shannon about earlier about the case of presidential immunity and whether or not the court would take into consideration what a big day this is with the big debate tonight.
Well, they do live in the world. The Chief Justice has a big role here. There's always been a sense of theater on the final days of the Supreme Court. They do tend to leave the big ticket items to the very end. But in terms of coordinating with the debate, it's not clear how that will come down. It's sort of interesting if both Fisher and Trump come down the same day, because both would have an impact on the election. I would expect that there might be an inclination to separate those two. But it would, in my view, be a good thing to have one of these cases still come down today, because it's relevant to the debate. President Trump is arguing that there's been a weaponization of the legal system. Many citizens view it that way, particularly the Manhattan trial against President Trump. That's going to be coming up today in the debate, I hope. And for the Supreme Court to resolve one of the legal issues would not be a bad thing, so that, we can have this debate with the knowledge of what the Supreme Court said the law is in this area.
All right, Shannon Bream and Jonathan Turley, if you'll stand by, we still could get some additional opinions, so we will be paying attention to that. We're going to squeeze in a quick break.
I'm Steve Ducey.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis.